Prior to joining the Law Society almost 7 years ago, I spent 36 years at Allen & Overy, where I was a corporate partner. I was very involved with the nuts and bolts of the law in relation to M&A and takeovers and joint ventures and so on. I spent a lot of time thinking about the efficiency of the law, about instruments you could use to do things, and about best practice. But in those days, I really took English law and the jurisdiction and the operation of our courts and tribunals as just there. They've been there forever. We're all very proud of them, but we didn't think very much about how they developed or were applied. And we only really considered, or I did anyway, things when they came up in the course of our practice rather than having a long-term perspective on trends. So at that time, really, when thinking about the rule of law, I and most of my fellow partners thought about how the rule of law might apply in other places, in other more challenging or dodgy jurisdictions, and what we, from such a solid jurisdiction, could do to support other countries that maybe had greater challenges. Now, perceptions in the city changed significantly in 2015 when Linklaters published a seminal report on the rule of law in England. And that report, which was followed up by a second report in 2017, authored by one of the very leading corporate lawyers in the city, Richard Godden of Linklaters, highlighted how much the rule of law, as we had traditionally understood it, had been undermined and chipped away at. And since those two reports came out, a lot more has happened that really causes one to question the application of the rule of law in our jurisdiction. So you think about the prorogation of Parliament, you think about the Internal Markets Bill with its plan to have some disregard for international legal obligations. You think about the National Security and Investment Bill, which would allow government potentially to unwind commercial contracts that have been freely entered into up to 5 years in the past. You think of the government's current interest in limiting judicial review and the extent to which the courts can look into how the law is applied by the government. So the challenge that many of you are going to face, as I have faced, is actually getting your mind around what the rule of law is. So the rule of law was really defined by Lord Bingham when he was Lord Chief Justice. And he came up with 8 principles, but really 2 of them are relevant for this discourse. The first is the law being accessible, intelligible, clear and predictable, and the second being legal rights and liabilities being resolved by the application of law and not by discretion. So what can busy business people and lawyers far away from the front line of access to justice and other such areas do about this? And more particularly, what can firms do which have the resources to devote effort and intensity to different areas? So I've got 4 things to do. The first is being involved before it becomes law, so looking at what's coming down the track. The second is looking not just at primary legislation, but also at statutory instruments, because today so much of the law actually arises through statutory instruments made under framework legislation enacted by Parliament. The third is looking at ministerial discretion, how that's applied or perhaps misapplied in different cases. And the fourth is looking at how the courts, including the Supreme Court, handle appeals which come before it. So the good news is, regardless of whether or not you're a solicitor or you have solicitors in your organisation, this is something that the Law Society can help you with in 4 respects. So firstly, we have a very impressive array of specialist committees scrutinising law and the development of the law in many different areas, including corporate law, insolvency law, competition law, and so on, other areas that would be relevant directly to business. And those committees are automatically consulted by the government, also consulted by the Law Commission, which looks down the track at future law reform and development. And when chunky new proposed pieces of legislation are coming along, they also will form working groups to delve into them in greater detail. Secondly, we have automatic access to government ministers, not just in the Ministry of Justice, but also in BEIS, in the Treasury, in the Home Office, in the Department of International Trade, to name but a few. And they will come along and take part in private roundtables, which we organise quite regularly to discuss issues. And those roundtables frequently are conducted under the Chatham House rule and would involve 20 or so senior participants, so people have a chance to have a real voice at the table. The third is we are regularly invited by select committees of both Houses of Parliament to come along and give evidence. And whilst sometimes it will be appropriate for me or one of my colleagues from the Law Society to give that evidence, very frequently we will want somebody else from practice to come and do it because they're real experts in the relevant area. So many of our most influential members give up time and attention to come and give evidence on behalf of the entire profession. And finally, we do have a strategic litigation function. So we are empowered and we're financed to intervene in cases where something is going awry, in our view. So this is most commonly on appeal, where we would join in appeals involving disputes between other parties where we think there's a fundamental principle of law at issue, and we have quite considerable success in deploying that tool.